Supplementary list fresh admission item number 1.
Yes, sir. These are all.
Yes, Mr. My question number, page 5, my lord.
What's the tax effect, sir?
More than 1 crore, 1 crore 31 lakhs.
All right.
Question framed in page number 5. The second question and first question important, whether the learned ITT was justified to record at paragraph 9 of the order that in the toe steel case, the demand notice has already been sent to the SSC on 31st March 2008, whereas no such material evidence exists in the assessment record of the said case to substantiate such observation. The assessment was served within the period of limitation under section 153(1) of the Income Tax Act.
So, what is the factual basis, sir?
That
Was it actually sent on 31st March or not?
not 31st March, later on.
So that how will it satisfy the requirement?
The order has been passed within due date and the assessment has been served later on.
Unless it is sent to the SSC, it's not.
Not within 31st March.
So then automatically that goes, sir. You said the questions.
The order is passed on 29/12/2019. It says to serve by 30th December 2009. It is served later on.
Challenged by the department in the present appeal is to an order dated 22nd December 2011 passed by the Income Tax Appellate Tribunal. In a bunch of appeals, that is ITA numbers 409, 10, 11, /CTK 2011 for assessment years 2002-03, 3-04 and 4-05. So short question is whether the assessment order was barred by limitation to section 153(1) of the Income Tax Act 1961 (IT Act). Question mark. Admittedly, the assessment order and demand notice, both dated 29 December 2009, were not served on the SSC by 31st December 2009. The CITA has held that although the assessment orders were sent before the expiry of limitation period, but they were sent for communication to the SSC after the expiry of the time limit for passing the assessment orders. Factually, therefore, the assessment orders and demand notices for barred by limitation. Paragraph the ITAT has agreed with the CITA and after referring to decisions of the High Courts and the Supreme Court, dismissed the appeals. Paragraph, having heard Mr. Chimanka Leonard, standing counsel of the department, the court is unable to take a different view in the matter. No substantial questions of law arise. The appeals are dismissed. Sir, all these appeals are?
No, only one.
Item number 2.
All right.
Item number 2 is, my lord, within taxable limit. Tax within tax
All right.
below.
That is, it has to be treated as withdrawn.
Yes.
The tax effect is below the monetary limit. The appeal is accordingly dismissed as withdrawn.
Item number 3.
My lord, The same order is passed in ITA number 48 of 2011. Commissioner versus Paradip Port Trust on 10/2/2022. Whether the dispute can be settled by an alternate dispute resolution mechanism, considering that the respondent is a central government undertaking.
When is that coming up?
On 19th April 2022.
All right. List on 19th April 2022 along with ITA number?
6465.
No. Along, what is that ITA number?
48 of 2011.
Along with ITA 48 of 2001. This is 64 and 65.
64, 65. And another two cases are the four cases, 89 of 2017, 90 of 2017.
Okay. Along with
listed.
89
Not listed.
and 90 of 2017. All right.
24, 2018, 156, 2018. 6, 24 of 2018, 156 of 2018.
What's the last number? 156.
156.
Along with
201.
all those four numbers. All right.
Item number 5.
A substantial question arises. Page 9. Page 9. Whether in the facts and circumstances of the case, the London ITAT is justified in directing the AO to allow benefit under section 11 to the SSC when the AO finding clearly established that the requisite conditions were not fulfilled by the SSC. Second question, whether in the facts and circumstances of the case, the London ITAT is justified in relating the addition of 1,33,90,000 made by the AO on account of receipt of capitalization fees. Third is the same, whether on the facts and circumstances of the case, the order passed by the London ITAT ignoring the relevant facts in regard to the receipt of caption fees as prefers. Caption fees is important.
Do you have any case law on capitation fee?
Yes. That I have cited in the tribunal order.
Where is that? Where is that, sir?
Only fact. 40 page 42. No. One minute.
They have followed the rule of consistency, sir. Earlier,
Yes.
AYs, they've been following a certain pattern.
Page 24. MJ Cherian 117 ITR 371 Kerala.
No, capitation fee, sir.
Yes.
This is not on capitation fee. This page 24, point 6.1. That citation. Citation, the highlighted portion is not about capitation fee.
They fixed it.
That is about statutory price for a particular commodity. It's not capitation fee.
Then
You wrongly quoted, I think.
yeah, page 36. Sorry. Page 36. Receipt of caption fees. Ratio of decision Honorable ITT Hyderabad Bench B in the case of Baduthala Education Society versus Assistant Director Income Tax 22 SOT and is really failed to the present case. Since the Honorable Bench held that since the associate collected money over and above that prescribed by the concerned authority for admission of student, such an amount was to be classified as a caption fees and it could not be said it was clear case of sale of education by the SSC and therefore it could not be considered as a charitable institution under section 215 of the IT Act. Page 36. After 5 line. And page 42,
Para 11.
para 11, yes.
Ah.
The assessing officer, on the basis of some discriminating material found during the course of search in the assessment year, presumed that there might be some receipt of caption fees in the earlier assessment year, which he estimated in spite of the search document available to him, did not indicate that the caption fees must have been received in the assessment year as well. The CJ relied on the decision of this ITT Colora in the case of Solzo.
It's all purely factual, sir.
Yes, factual.
All right. You say the department is an appeal against an order dated 25th April 2012 passed by the Income Tax Appellate Tribunal, Cuttack, which Cuttack, in ITSSA numbers 56, 57, 58, 59, and 60, public CTK, public 2009, for AYS 2000-01 to 2004-05. One of the questions sought to be urged. The question sought to be urged is whether the IT-80 was justified in deleting the addition of 133,90,000 on account of receipt of capitation fee. Question mark. Having carefully perused the orders of both the CIT-A, concurrent orders for both the CIT bracket A and the IT-80 on this aspect, the court is of the view that it turns entirely on facts and gives rise to no substantial question of law. Accordingly, the court declines to frame the question as prayed for. The appeal is dismissed.
Item number 6.
6, I am appealing. This is a common order has been passed, annexure 3. I am confined to only the assessment year 9 and 10. That is item number 121 of 2000. The question, revenue was framed the question. I start paragraph 6 of the appeal memo. Whether in fact and such the case, the London ITA justified in deleting the addition made by the EO on account of discrepancy in the liability claimed by the assessee against customer advance, ignoring the fact found from the seized document. Next one is whether the fact in such a case.
What's the tax effect here?
This is not use tax effect. No.
All right.
In addition, may account unexplained cash during the search without considering the fact. Your Lordship, that is the state we are also take you to the finding of the tribunal starts from page 53, paragraph 21.
Yes.
Yes. For the assessment year 19, being this search year, we are unable to satisfy ourselves with the contention of the rival parties that declaration of income being sales operation amounting 1 crores could lead to addition of rupees 9.10 crores when the learned ITIT has himself
CIT-A.
Sorry,
When they learn at CIT-A.
appellate authority has himself directed the deletion of 8.21 crores being an arithmetical mistake in calculation of the total liability on account of advance from customer on which the purported percentage of suppression of sale has been computed. The assessee indicates liability more than what the IT department has computed so far as the department had the benefit of such material as well as the incomplete books
This is
of account.
perfectly justified, sir.
That's not
Perfectly justified. You say the present appeal by the revenue is directed against an order date 11th May 2012 passed by the IT-18 ITSS number 122, right?
sorry.
122, ITA number
IT 121.
121.
Yes. Sorry. 122 CTK
122 oblique CTK oblique 2011
for the assessment 9.
for the assessment year 9-10. The questions ought to be urged before the court concerns the deletion of the addition made by the assessing officer on account of unexplained cash found during search. Full stop. Paragraph. The discussion in this regard is contained in page para 21 of the impugn order of the IT-80, where it is noted that the AO has proceeded on surmises. No, proceeded on an arithmetical mistake in calculation. To the extent of rupees 8.21 crores, which had to be deleted by the CIT bracket 8. Paragraph. No substantial question law arises. The appeal is dismissed.
Item number 7.
7-8 is similar. Here the question is imposition or levy of interest. Levy of interest, not the fact remain that SARS is conducted and this is the cash and all this is account on you'll also see running to 39 of the brief. That is 27 March 2009 and this is led to assessment year 9-10.
Oh,
So the stand of the appellate authority come to finding that as because the cash with the department, so it is automatic that he has to adjust the advance tax whatever is determined because he has not requested. But my stand, my question here is the advance tax liability under section 210 section 208 and 209 has to read together. If you can see 208 and 209 for a moment. 208 is speaking about the advance tax liability.
again, what's the tax effect here?
But it is interest, only interest.
No, what is the tax effect?
Not
I think it won't be much.
tax effect, not. Tax is the 6 crore 88,58208 running page 9.
All right.
The fact of the case is that they have relied on the judgment of various high courts. That I have checked the judgment and find that 209 has not been discussed in this judgment because 209 says the date of payment of advance tax. Now it is June. In that point of September, December, and March. So if the cease has made 27 March, then he has to
what
pay.
is the harm? What is the harm in allowing him to pay the advance tax by cash seized during the search?
No, the question is not the account has been seized as 27/9/2009. Assessment related to 9/10. The fact remains the tribunal says because it is within the cash is within the department. So it is duty of the department while you are levying tax, you have to adjust the advance tax. Here the assessing authority has calculated the advance tax on the date of assessment. I am not on that. I am on the issue whether the advance tax date of payment has considered or not. Date of payment is September, then December, then March 15. And after that the account receipts is therefore my contention is that 208 and 209 has to read together. Otherwise, calculation.
What is the harm in permitting him to pay the advance tax to the cash seized?
No. He says the issue is here. He says that you have to calculate because cash is the department. So you paid the tax. Department has paid the tax on the date of assessment. After is calculating the detailed liability and asset, and this paid the tax. Then interest is accrued. Tribunal, let's see the order of the tribunal. State will also see the finding. Running page 41.
Yes.
We have heard the rival parties and perused the material available on record. On our careful consider the fact and circumstance of the case as brought on record by the authority below, we are inclined to find favor in the contents of the Learned Counsel for Assess so far as the Learned Counsel of the Assessor submitted a compilation of case law relied upon by the Learned CITA so far as case of Sudhakar M. Sethi versus CIT Supra, which has been brought on record as per the amended provision law, there is no requirement to seek any request from the assessee for adjustment, which therefore clearly indicate that it was a procedure delay in so far the case of Rama is Sarada was a DCIT decided by DCIT so and so. We held that liability to pay advance charge constitute a part of existing liability as per section 132B1I as per section 132B of the seized asset to be applied to the discharge of existing liability. The assessing author did not insofar as having created demand including interest computed by him under section 234A, 234B and 234C stood adjusted when the refund was not accordance with the provision of IT Act. As also been considered by the Honorable Delhi High Court. I am having the judgment, so I will place it. Delhi High Court in case of Vishwanath Khanna versus Union of India, reported so and so. In other words, revenue stand to charge the interest twice one on the basis of seizure and after lapse of the period by computing the period in which lapse is not on account of assessee has again been burdened with the revenue after charging interest which should rather than in favor of the assessee for adjustment. The Learned Counsel for the assessee has submitted that the seized cash was on account of capital gain was to be paid in the last quarter only, and therefore the liability of advance tax was paid for the assessee and seized by the department.
This is a possible view. There's no case law, nothing here, except Delhi High Court.
Yes, in the Delhi High Court, let's kindly see the judgment. He has said that, not I am one copy, sorry, not one copy.
Yes. No, this supports the SSC, I thought.
It is not. Here it distinguishes that my submission is not that the date of payment has not been considered. His wholly case is that if it is within department has to pay. I am not disputing that because after the amendment, no request is required for payment of tax advance or something. But when the date of seize is 27 March, then how will the liability will be escaped for payment of advance tax liability and the interest? Advance tax liability, there is no issue because that has been adjusted. But so as part of the interest, how can it not be deleted?
Not delete. He says just adjust.
Yes, Lord. Adjust. He says, Lord, it should not be. Kindly, I am reading, Lord. We therefore inclined to uphold the order of safety as far as the place reliance on the various judgments brought to record against no controversy has been submitted by the CITDR.
Yeah, you can't charge interest twice, he says. That's correct only.
There is no twice interest now.
Yes.
There is one interest.
Yes.
Therefore, my humble submission is 208 and 209 has to read together.
No, you are charging interest.
Yes, I am charging interest. But he said that no interest will be charged because it is within the cash department, they seize the cash and everything. So it is voluntarily he has to deposit. There is no issue that I am not saying to know that. But my issue is, if it is not prior to the assessment or a day before, prior to the date of payment of advance tax, then it's all right. But kindly mark the date of seize and seizure. Date of seizure is fine place 27 March 2009. The assessment is 9/10. Then my humble submission is blood interest will be chargeable so far as last 3 quarters.
No, I think the question is not about chargeability of interest. It's about adjusting the cash for against that interest. That's the question. Adjusting the cash seized.
Yes. You'll also see the running page 42 is also considered by Delhi High Court in case of issuance. So in other words,
just see the submission of the Learned Counsel with SSC that the seized cash on account of capital gains was to be paid in the last quarter only, and therefore the liability of advance tax was paid for by the SSCs or seized by the department is an undisputed fact, which the AO noted on the basis of assessment orders.
They have calculated and paid the tax and interest charge by the department as according to their cash seized. Now the tribunal says you cannot impose the interest because you are having the cash and everything. therefore the interest is not chargeable. My submission is that if it is detected seized on 27 March 2009 and is relating to assessment of 910, the interest is applicable. And that question has not been dealt with in the Delhi High Court.
That's okay, but why should we not accept the view taken by the department, the IT8 is requested?
IT8 does not consider that the section 209 because if you I'm pensing the date has been specified the September, December and March. He has to pay percentage of the advance liability has to discharge. And if are not paid, then interest is automatically be attract for payment of interest. So far as the advance liability is concerned.
Are these companies still around? They're all private limited companies.
Private income, I have no idea.
For 10 years, the appeal has not even come up for hearing,
No,
even once.
two are the same issues. But I have not searched all these judgment which are, but no here it has been stated that the calculation of interest and date on cease. It was prior to all the cases, prior to it was cease and thereafter the assessment came into operation. Therefore, admittedly no interest will be charged after the amended provision because no request was made by the assessee for adjustment of the advance tax.
All right. Let's see. Notice confined to question number 2 as set out in paragraph 4. On 9th May, the notice be issued by speed post. The tracking report be placed in record for the next day.
Right.
7 and 8.
Supplementary 9. Item number 9.
None appears dismissal non possible.
Item number 10.
Requisite by requisite by
Profiling of requisites.
You should let him know what for notice, whatever is the rules.
Right.
Just tell him notice returnable, give a date, please.
Notice returnable by 9th May.
I'm sorry,
Supplementary is item 10, sir.
Yes. Here the petitioners have filed this case with a prayer to take over the possession of the government lands from the private persons as they have encroached forcefully and also recorded the government lands in their names by practicing fraudulent manner.
Where are they? Which opposite parties are they, sir?
Opposite party, all are government matter.
No, sir. These encroachers, where are they made parties?
The encroachers are much more, my lord.
Whatever, sir. Where are the names of the encroachers? Where are they made parties?
I am not made party to them.
Without making them parties, we can't pass orders in these kind of matters.
Then
Counsel for the petitioner seeks leave to withdraw this petition with liberty to make a fresh representation naming the encroachers. And after following up on such representation to seek appropriate remedies as may be available to him in accordance with law.
in this case, I have annexure 1, the government lands are there.
Next.
Annexure
Item number 11.
it is not.
None appears dismissed non prosecution.
Persons.
Item number 12.
None appears dismissal, non-prosecution. 13 also.
Item 13.
Item number 12, sir.
Yes, carry on, carry on.
Sir, this present petition is filed against the implementation for RERA Act and ORERA.
So that's already happening, sir. Not at this stage. You can go before RERA and ORERA or
Not a single authority is implementing such.
no, you go before them. You go before them. All those authorities are very much there.
No, sir. Party has given representation to all the authorities. Even principal secretary written letters to the ORERA secretary and ORERA secretary also.
Who's not obeying?
Sir?
Who's the person not obeying?
The whole, every sub-register of authorities are not following the act.
So we already have petitions of this regard. Mr. Mohit Agarwal's petitions are already.
Last year we have given an order to give some instances.
So there are already PILs which we have entertained. We don't want to multiply PILs. There are already PILs pending in this court
So still they are not
on the
implementing
question
the
of
orders.
non-implementation of the Real Estate Regulatory Authority Act. The court does not intend to multiply PILs in this regard.
So the fraudulent
The
activity
PILs, this petition is dismissed.
continuously going on.
All right.
Item 13.
Item 13, sir.
Item number 14.
Sir, item 13. Sir. So it's the petition against the illegal and unfair attitude of the opposite parties for not taking any steps to declare the shops unauthorized and dilapidated constructions to sealed.
Where are they, sir? Where are they made parties, the owners of these shops?
So it's a government land.
Where are the owners of these shops or the people who are running these shops? Where are they made parties?
Sir, the government is party. The BMC is continuously.
Sir, you are aggrieved by some shops running on government land, correct?
Government land, yes.
Where are those shopkeepers
Sir,
made
BMC
parties?
collecting revenue from those shops.
Where are they made parties, sir? The petition.
So it's on a GA government land. Yes.
I don't really understand the question. What to do?
The people are using it as a through fare.
See, you're so casual about the whole thing. Do you understand the question?
Yes, sir.
What is the question?
To make them parties, the shopkeepers.
You want some orders to be passed. If we allow your petition, those shopkeepers will have to be thrown out.
Yes, sir.
Should they be heard or should not be heard?
By the time the order will be passed, the building may be collapsed, sir.
I see. So you delay it, therefore. Don't make them parties. By the time the order will be passed, everything will be over. You don't do what you have to do, and you are trying to put the blame on the judiciary. I like this very much.
My representation is given all BMC.
Sir, answer this basic question. Suppose you were the shopkeeper and somebody has gone to the High Court complaining against you, you are not to be made a party.
Sir, those are government lands
Anyway,
and they are.
There's no point in
Using on
all
rents.
right. You are not in a frame of mind to understand the question. We cannot help you.
It's under the Puja committee and they are rented those houses.
All right. The counsel petitioner is disinclined to understand that action to be taken at his instance against shopkeepers whom he says have illegally encroached on government land cannot be ordered without making such shopkeepers parties to the petition.
Sir, it's not enclosed. They
Since-
are allotted those lands.
All right, whom he says are running shops which are dilapidated cannot be passed without their being paid parties to the petition. The petition is accordingly dismissed.
Item number 14.
May I please, my lord. My lord, in item number 14, the petition challenges the validity of the notice issued under section 148 of the Income Tax Act 1961. And all these cases are fixed for hearing on 7th of March.
All right, list on 7. All right.
And stay maybe.
Supreme Court has already admitted the Allahabad High Court case on 8 and it posted to 15th March 2020.
That day you can mention.
No coercive action.
All
Item
right,
number
notice the excess notice, no coercive action till the next week. All right.
Item number 15, my lord. My lord, in this case, again challenges the validity of 148, but Here the sanction has been given by the ACIT, not the Commission of Principal Commissioner. And this case has been decided in a bunch of cases in read petition number 20919 of 2021, decided on 21/1/2022.
Within that, it is 1516 and issued the notice on 31/3/21. And
Yeah, beyond 4 years. So it's covered. You see, in view of the decision of this court dated
21/1/2022 in WC number 20919 of 2021.
the impugned notice is squashed, the petition is disposed of.
Obliged, my lord.
Orders item 16.
16, your lordship. Notice as.
No such person in the address.
Yes, ma'am.
No steps have been taken to serve the opposite party. Therefore, in the last 10 years, leaving the question of law open, the appeal is disposed of.
Item number 17.
None appears dismissed for non-prosecution.
Item number 18.
18 and 19, both are similar to item number 34 and 35. Day before yesterday, this matter was listed. I pray my lord to tag with that matter. Today's list 34, 35. The batch of case challenging the violation. Today, my lord, 34 is there.
We'll take it up there.
34 and 35, both.
All right.
Item
18,
number 20.
19, both.
Item number 20.
The 20 is the same, my lord. Same with item 34 and 35.
All right.
Item 21.
21, 22, my lord, similar matter. Dinabandhu Sahu versus Union of India and others, cover matter.
No, my lord, lordship kindly see page 11, annexure 2. There is no occasion for the RTO Cuttack to demand additional fees. Here the NOC issued by the RTO Cuttack to RTA Rangareddy. So lordship kindly see page 11.
This is the usual order. So what do you say, sir?
My lord, so far as the judgment of this honorable court quashing that additional fees, I have no quarrel. My lord, here the no cause of action arises for the petitioner to file here. Here, my lord, the NOC issued by the RTO Cuttack to RTA Rangareddy, my lord.
Okay.
Lordship kindly see page 11.
So he has to go to the appropriate court.
Not he has to approach the RTA Rangareddy and
That's what.
produce that NOC. In that event, RTA Rangareddy may
Raise a demand. All right. You withdraw this petition, sir?
My lord, already cancellation of NOC not submitting the other state. When issuing authority of the RTO Cuttack, property party one, I am application to authority of.
Then whenever that happens, you file it again. Consequently, the petitioner seeks leave to withdraw this petition with liberty to seek appropriate remedies available to him in accordance with law. Which item is this? 20?
next is
21, correct.
21 is 7.
This is 21, sir.
22 is 7.
22,
Item
Same.
22, sir.
Same.
Item 23.
Item 23, there are some defects. I removed the defects.
All right. Defects be removed within 1 week, list thereafter.
Item number 24.
Defect has been shown that representation was not submitted, but in fact, this application has been filed pursuant to my lord's liberty. But this
All
is
right.
the order, my lord.
All right.
That may be.
What's the matter about?
It's a PIL, my lord, challenging the unauthorized encroachment of government land, my lord. Where my lord was pleased to direct me to implead some of the persons who may be affected.
Only one has been impleted.
Yes, my lord, that under the RTA Act, I could obtain certain information. My lord, so as per the information, I could get the details of this person only. So my lord was pleased to direct him to implead. But there are, yes, my lord.
There must be a whole colony, sir.
My lord.
Must be a whole colony of people.
Yes, my lord.
You only picked up one person there.
Yes, my lord. I could get details from the RTA, my lord, only with respect to that was also filed previously, but this person was not impleaded. So my lord, I directed to implead that person and
You'll
file
only
a
ask
fresh
them to take
application.
instructions. Who's appearing for the opposite parties? The Tahsildar, Barbel.
I'm appearing for the state, Your Lordship.
Item number 24. 24.
Before issuing notice, the court would like to know the ground situation. The Tahsildar Barbel will submit the status report by the next date. List on We'll have it in May, sir, after all these elections. 11th May.
Oh, bless you.
Item number 25.
Oh, bless me.
Your Lordship, Your Lordship, an affidavit has been filed with the photos, Your Lordship.
Given him a copy.
Yes, my lord, I've received a copy, my lord.
State Election Commission.
Where is the SEC? State Election Commission.
My lords, I am appearing for the State Election Commission, my lords.
Yes, what is your response? You've seen the affidavit?
My lords, kindly see the annexures, they're all GPS images, my lord. They're not real-time images that have been provided.
Please.
If your lordship permits, I'll
You
give
go
an
there, you go to the booths themselves and you
my lords,
verify.
they are total 91,913 booths.
No, these very booths, he's giving you a sampling. If you are doubting it,
Yes,
you
my
go
lords,
yourself and see it.
My lords, kindly see the annexures, they're all GPS maps images.
So if you're doubting it, madam, if you're doubting it, you go to those booths yourself.
My lords, I'll take.
Somebody is taking the trouble of filing an affidavit. It is so casual, easy for you to simply doubt it.
My lords, I'm not doubting.
If
Actually,
you're not serious about it, we'll mandate it in every booth.
my lords,
You better be serious about this.
my lords, I'll verify. I'll take instruction. I'll verify.
Yes.
If your lordship permits, I'll file an affidavit.
No, we are not question of permitting. We want you to file an affidavit.
My lords,
Yes. And what you're doing for this.
my lords, I'll file an affidavit, my lords.
Your Lordship, may I press one thing? The letter they have filed dated 24/1/2022, they haven't specifically made any provision for Braille. While the State Election Commission on the letter dated 26 wide annexure 1, they have made provisions for Braille. The last date they have filed the memo.
An affidavit has been filed, additional affidavit has been filed with the petitioner enclosing photographs of a sampling of polling booths where, according to the petitioner, no facilities have been made available for persons with disabilities. Council adds that, in particular, no facilities have been provided for the visually challenged. No Braille facilities have been provided for the visually challenged. Council appearing for the SEC states that the photographs will be verified by a spot visit to those very polling booths by officials of the SEC, and an affidavit will be filed before the next date. We'll have it on Tuesday.
Obliged. Your Lordship, may I be permitted to file on video the situation of Your Lordship? Maybe
nobody prevents you, sir. How proactive you want to be is up to you. Yes.
Obliged.
For admission, item 26.
May I pray your lordship? In
Yes.
this case, my lord, the earlier council, Mr. Pati is no more.
Yes.
I have already filed my Bhokladnama, but my name is not reflected in the list. my lord.
All right. Anyway, you're there, sir. Tell us what it is.
I have challenged the annexure 1, my lord, cancellation of the allotment made by the local land committee, my lord, Rahul Kela. And allotment committee, that is annexure 1, page 19 of the writ petition.
Yes.
The petitioner is a printing press owner. Has
But
applied
all
for
these disputes have to come in a writ petition to the High Court like this. Some calculation of some demand by the corporation against you, you come straight to the High Court.
I don't know. They have cancelled my allotment, my lord. That's against the cancellation of allotment. I am for my allotment.
He had applied for a land that was cancelled by the committee, and that order is applicable before the government. And the very ground for the cancellation is that he has got another leasehold land in Rourkela city, and which he is not eligible to get. And he himself has submitted an affidavit before the allotment committee. That is annexure B of my counter affidavit, that I have got another piece of land in Rourkela. Annexure B by 1, page 11.
Here the district industry center has recommended for allotment of land of 56 decimal. The government has allotted only 8 decimal. Thereafter again
the first condition is that you should not have any other land.
Yes, ma'am. They have allotted 8 decimal of land, which thereafter the DIC has recommended for allotment of more land, my lord. That is their ballot. That is the annexure. They have filed that is annexure 12, my lord. at page 34. On the basis of the recommendation of the district industrial center, my lord, the petitioner applied for
The
allotment of
district
more land.
industry center may not be aware whether you have another piece of land at Rourkela, all right?
Yes, they have ever, my lord. They have
Sorry?
said that the land which has been allotted to the petitioner is 8 decimals and that is inadequate for the industry. Therefore, they have recommended for more land, my lord. That is there, my
Land
lord.
allotment committee. And the basic requirement is that the person should not be allotted with any other commercial land in Rourkela city. And he is not eligible on that score. That is why,
No, my lord.
and apart from that, I have specifically taken a ground. This order of the committee is appellable before the government.
So you
state
file that
government.
appeal, sir.
Let him file an appeal. And
Counsel.
after 10 years, more
If you
than
want to file an appeal, we can permit you to, if you don't, we'll dismiss it on the ground that you have alternative.
My lord, we will file the appeal.
Counsel Minister seeks leave to withdraw this petition with liberty to file an appeal against the cancellation order of the land allotment committee.
To the state government, well, to the state government under
To the
rule
state
9 of
government.
the
All right.
rule 9 of the OGLS.
Under section?
Under rule 9 of the OGLS rules 8
Under rule 9
1987.
of the OGLS rules. This post office withdrawn with liberty is taken. All right.
Item 27.
27, may I please your lordship? I am from the BC, my lord. I am appearing from BC. Am I audible?
Yes, yes.
Here is a case, my lord. The 3 writ applications are there, my lord. The WPC number 91 of 2020 and 2010, 92 and 93. 93 was also there, is there in the list, my lord. But since it was dismissed for default, a CMA is filed. That is also been indicated in the list, my lord. The case, since the 3 cases arising out of the one dispute, the industrial disputes, and 3 industrial dispute cases have been instituted as per the reference made by the state government. So we have filed 3 separate writ applications, my lord.
Here it is covered that state government cannot make a reference for NTPC.
My lord, I am appearing for opposite party number 3. The crux of the case is that, my lord, if your lordship will see
No,
the
you are
annex.
central government, right?
So, my lord, no, I am not. In this case, I am not appearing for.
Whom are you appearing for?
He's for this. He's for the labor union.
The labor union.
Labor union opposite party number 3.
So reference is to be made by the central government, correct?
Yes.
No, it is made by the state government.
No.
The case
law
of the
requires it to be made by central government, correct?
My lord, sorry.
The law requires it to be made by central government, correct?
Sorry.
No. What is your stand?
My lord, my stand is that as the annexure 1, it says that the conciliation report is in the year of 2007. Annexure 1 reflects. And thereafter, my lord, after conciliation failed and the present petitioner company has filed the writ petition before this honorable court, and this honorable court, by this honorable court's order dated 5/9/2007, it has been directed both the party for conciliation. The crux of the case is that.
No. Why don't you answer the question, sir? The question is, can the reference be made by the state government? That's the question.
My lord, my only submission is that the failure report and all the conciliation before the notification, my lord. That is at page 8, my lord, which, my lord, I am answering the pertinent point, my lord. The opposite party number, while making a reference to the tribunal, had its impugned order dated 26th May 2008, which has merged after the notification of 5th May 2008. 2008, before that, this is TTPS, my lord. That is the only point.
What is the stand of the state government?
My lord, here initially, my lord, in the year 1998, my lord, we had made by virtue of a gazette notification, we had made the reference, my lord. Thereafter, my lord,
there's a notification 2008 of the government of India where the earlier notification was rescinded and the power bestowed upon the state government was taken back. My lord, Lordship may kindly see the counter affidavit filed by us. Here, my lord, we have relied upon the judgment of the Honorable Apex Court in two cases, my lord, para 7 and para 8. There, my lord, it has been left open to the tribunal to ascertain because it's a question of fact as to which government is the proper authority.
No, here we should know how NTPC, where's the question of you say admittedly NTPC is a central government public sector undertaking, and the reference of any dispute, labor dispute, has to be made only by the central government. Full stop. In that view of the matter, the impugned references made by orders dated 3/12/2009 by the state government in ID case numbers.
My lord,
3 cases, right?
Yes, my lord. I'm giving the number. 302.
Take it from the prayer clause. 302 is one, then
WPC number 92. My lord, here the ID case is 302 of 2008.
And then the other 2 prayer clauses are hereby quashed. This will not prevent the workers' union from pursuing the matter with the central government for making of a reference. The petitions are disposed of the above terms.
Connected
91 and 93.
Cases, my lord.
Only one prayer that my learned senior, Mr. Ratha, is expert. So my name may be indicated so that.
Right, sir. 93 also, right?
Yes, all the 3.
Yeah.
Item number 28.
No, 93, I'm sorry, my lord. 93 has been dismissed for default. The CM appeal is pending.
So that CM appeal will
that has
have
to be restored.
restore it, and then all 3 matters. All right.
Item number 28.
Against the inaction and the arbitrary action of the opposite parties, this petition has been filed to quash annexure 5 millionaires. That is the order of the Tahsildar. This is a case under section 81 of the Orissa State Abolition Act. 81 says for a settlement of a suit land. But the application before the Tahsildar was rejected, for which appeal, he preferred appeal before the additional district magistrate. Page 9, my lord, kindly see. Page 9. The appellate authority had the matter when the OA case was rejected. The petitioner went on appeal, and the appeal was allowed by the additional district magistrate Dhenkana, and he remanded the matter for a reconsideration. But till now, the Tahsildar, who is the OA collector, did not consider the matter, and for which, and thereafter what happened, my lord, the collector issued a notice, encroachment notice to the petitioner to evict the land. So this is the application under Article 226 and 227 to quash the order of the Tahsildar, who has directed to show cause in an encroachment case whenever this matter relates to Orissa State Abolition Act, and the petitioner is fully entitled to be settled.
On remand, what is the case number before the Tahsildar?
My lord, our own High Court.
1 minute, sir. Just listen to the question.
My question is, your lordship may direct the Tahsildar to reconsider my case under Orissa State Abolition Act.
That appellate order that is not available in my case record.
Page 18. Page 18 is the notice.
No, notice is there.
Notice. All cases are rejected. All cases are. I have given.
What I understand from the argument of my learned friend,
that appellate court remanded the matter.
Yes, remanded the matter.
I want to know that number.
That order is also not available in the case. And if my responsibility,
let him hear both together.
Let him appear before the Tahsildar in that encroachment case and file all these documents. Tahsildar will take care of it.
No, that should be decided in the provision of OA Act.
Let him have.
No,
Tahsildar has to do 2 things, right?
So far as the encroachment case notice you are challenging, that is arising out of a OPLE proceeding under the Orissa Prevention of Land Encroachment.
Correct.
So you appear before the Tahsildar and say that there is an appellate order under the OA Act. If that is so, the Tahsildar will take care of it. But that appellate order is not available in my record. Let me see. ଅଛି କି?
Case na 18 page
ନାହିଁ
18
ପରା।
notice ଅଛି ନା ନାଇଁ
ନା
170
ନାଇଁ appellate order ଟା ନାହିଁ।
So OEA Act and OPLE Act.
That appellate order which is
Under OEA Act.
under the
OEA
OEA
Act,
Act, that is not there in the record. That is what I am saying. What he is saying, that is not annexed to the writ petition.
the appellate order is here. The
କାଇଁ ଦଉନାହାନ୍ତି?
appellate order page 9 you see
ନାହିଁ ପରା।
ଅଛି ଦେଖନ୍ତୁ page 9
ମିଛ କହୁନି ମୁଁ।
ଆଜ୍ଞା ଦେଖୁନାହାନ୍ତି appellate order encroachment case କଥା
8 ପରେ 12 ଦେଖନ୍ତୁ।
ତେବେ ଆଜ୍ଞା ନେଇ ଯାଆନ୍ତୁ ମୁଁ ଫାଇଲ।
What is your name? The party's name, sorry. What is the party's name? Petitioner's name? Srinath Prushti. His name is not here at all. Kulsnani Prushti is there.
ସବୁ କେସ୍ ଗୁଡାକ decide ହେଇଛି ସେ ରିମାଣ୍ଡ କରି ଦେଇଛି।
So where is that Prushti? Srinath? No.
Srinath Prushti.
Srinath Prushti, where is he figure in this appeal?
Annexure 1 is his record that he has got a pata. He has got a pata in the year 19.
No, sir.
No, annexure 2.
In annexure 2, where is his name?
Petitioner is not a party in this appeal. ଦେଖନ୍ତୁ। ଆଉ କାର order ଆଣି ଦେଖିଲେ କଣ ହବ?
ସବୁ ଯାକ all the cases Miller.
Not the case of your class. Not the case of your class.
All the cases are dismissed by the OA collector. So all persons approached the.
No, you talk about your cases. We forget about everybody else. Where are your appeals?
Lord, as my Lord and friend submits that the Tahsildar may be directed to dispose of the.
All right. You say the petitioners agreed by some an encroachment notice issued by the Tahsildar. Oh, which place this now? Kamakya Nagar, then Canal, under the OPLE Act. He claims that the petitioner's case under the OEA Act is also pending before the Tahsildar pursuant to a remand ordered by the additional district magistrate in an appeal filed by the petitioner. Paragraph, it will be open to the petitioner to appear before the Tahsildar pursuant to the impugn notice and place all facts within his knowledge and documents relevant to the case before the Tahsildar for his decision. The petitioner will appear before the Tahsildar on 4th April 2022, and the orders on the show cause notice shall be passed not later than 3 months thereafter. Till then, status quo as of today shall be maintained. The petition is disposed of in the above terms. Both cases, I think.
Item number 29.
My lord, another case. The appellate order is available. The order of the.
It's all right.
My lord,
Okay.
page 16.
All right, sir. All right.
Item 29.
You say neither the charges have been deposited nor paper books prepared. No steps have obviously been taken, leaving the questions of law open for decision in some other case. The appeal is disposed of.
Item number 30.
May I please your lordship? This matter, let's see. The present petitioner.
We'll have it on some other day, sir.
Lordship,
In fact, well, after hearing on in the month of April 2021. there
Oh,
is
it's a disposed of case.
No, on 29/4/2020, my lord directed both the parties to file the written notes of argument. And I have already filed.
I have
Petitioner has-
also filed. No, that is no. You have
So you
filed
lord-
it.
well, if both the sides have filed the written notes, so you lordship may close the matter.
No.
Actually, we've heard it actually.
No, Lordship has never heard it, this matter. Only
Correct.
Lordship was pleased to say, you file written note of submission. Only I'll take half an hour, any date, Lordship, in the month of March, any date. Unless my lord hear the matter, that will be very difficult to. There are annexures.
Issue is very limited.
Issue is very limited. Question is, allegation against the petitioner was while working as
All right, we'll fix a date.
10th of March, Lordship suits, my lord.
No, it doesn't suit. So we'll keep it for.
Because 7-8
12th of
times
May.
it is adjourned due to paucity of time by the
All right.
honorable court.
Right.
Pardon, my lord.
Item number 31,
Pardon, my lord.
12th May, sir.
It's all right. Call up the next matter.
Item number
Pardon,
31.
in my cases, your lordship directed the Tahsildar not to maintain status quo.
Status quo ହେଇଛି status quo.
Item 31.
Come to the mic, sir.
It is a PIL matter.
Yes.
The petitioner's allegation that OP number 4, my lord, is no more because he expired in 20 due to COVID. He has encroached, two plots of in nature of Kisam Gochar, constructing some construction under the guise of school ghar. And
if she's died, you made, who is now in possession?
Possession, my lord, he's legally, he has constructed some.
So you have to make the legal heirs a party?
Yes, sir.
Counsel the petitioner seeks leave, informs the court that opposite party number 4 has expired. Yes, LRs we brought in record. This is on 11th May.
Item 32.
All right. May I please, Your Lordship? I have entered appearance, my lord. After death of Mr. Naik, I have entered my appearance and last time my name has not appeared, my lord. The matter related to public interest litigation, my lord. Challenging the violation of the construction made by the opposite party number 6, madam, with regard to the hydroelectrical power station at Gulmi in the district of Koraput, my lord. Gulmi is a tourist spot, my lord. And the opposite party number is, Your Lordship, kindly see, I have given the date chart, my lord.
Who's for the state?
I am appearing for the state, madam.
I am appearing for opposite party number 6.
Yes.
This matter, identical matters were filed earlier by way of a writ petition. There were some directions, and matters were also filed before the NGT.
Exactly, that is what I am saying.
Honorable NGT has passed an order.
Present petitioners are no concern, madam.
Carry on, Mr. Ravi.
Kindly take page number 88 of the third additional counter, which has been filed on the 24th of August 2021. All these allegations, in fact, these allegations are cut paste, verbatim copies in the earlier writ petition and also before the NGT. So repeatedly the same allegations are being made. NGT has inquired, a committee was appointed, committee went into all the questions. All the issues have been resolved. Would your lordships kindly take this order of the NGT, page 88 of the additional.
Were these petitioners a party?
I am for they are the senior citizens of Koraput district.
No, were these petitioners a party there?
One of them was.
Earlier they have filed a writ application.
One of them was a party.
No, they are not the party before the NGT.
One of the petitioners.
No, madam. No. My answer is no.
But your lordships will kindly find that the allegations are cut paste allegations. I can show that to your lordship.
Exactly, that is the issue involved in this writ petition is also the similar issues are involved in NGT. And the NGT, and apart from that, if your lordship will see the representation at Annexure 13 at page 50, the allegations are all cognizable before the NGT. And let him go to NGT. If at all the petitioners are independently willing to fight out the cause, let them go to NGT.
Is it still pending in the NGT?
No, there is a final disposal. The Honorable NGT, there was a committee which was appointed, a special committee. The special committee inspected the place. My lords, this existence of waterfall, all these allegations have been gone into. I can take my lords to the details of the order passed by the NGT. If my lords can locate that additional counter.
No, we've got that.
Page 88, my lords have it.
24th September order.
Absolutely, your lordship. And your lordships will find that these very aspects have been considered. And my lords, so far as the appointment of the committee, etc. is concerned, my lords will kindly see in page 93, paragraph 10. This is the report which has been prepared by this committee after going into all these allegations. Every one of the allegations which your lordships will find in the present public interest litigation was also the subject matter in that litigation. But so far as public interest litigation is concerned, obviously I can't be saying anything in the nature of res judicata or anything like that. If these aspects have been covered, the fact that these petitioners were not before the Honorable NGT may not make any difference. That's my humble submission.
Yes. Your Lordship, can turn to page 30 of the read petition, my lord. Annexure 6, my lord. Annexure 5, my lord. Another joint committee was prepared, my lord. And it is found that they have every violation, my lord.
No, what's the date of that report?
That is it, your Lordship, the date is 16/5, that is 23/8/2016, my lord.
So look at this annexure B6.
Yes, my lord. I have seen, my lord. Because
so that is an order of 24th September, sir.
Yes, my lord.
So what are you doing about that order? You can challenge that.
That committee has inquiry committee has conducted.
No, but that was 5 years ago.
Petitioners, my lord.
That was 5 years ago, and now in 2021.
Yes, my lord.
The NGT has passed an order.
The very same authority, my lord, without taking into consideration all the aspects that would be raised by the petitioners.
So if you are agreed with the NGT's order, you have to challenge the NGT's order then.
Well, anybody can challenge. We are not, my lord, we are not the party before.
Even if they are not parties, if they are aggrieved, they can challenge it.
First time we have come across this order has been passed.
No, they have filed it in the rejoinder affidavit.
Thereafter, I have filed the reply, my lord.
You filed a reply?
I have given the reply, my lord, to the third additional affidavit.
One set of petitioners are here and another set of petitioners before
At
the
the behest of the opposite party, that has been done.
same allegation.
My specific allegation of the petition filed before the NGT at the behest of the opposite party number 6.
Please.
Yes, that is fact, my lord. The very same authority has conducted the inquiry and it is found that there is a violation, and the very same authority said that it is already compensated. Forest land will be compensated. There is a stipulation that 4 meters where will be constructed. Now they are constructing 15 meters. Entire forest will be submerged. We are not opposing the construction. We are only opposing the deviation.
So you are only opposing the
deviations, man.
Deviation.
Yes, man. Within the stipulation, whatever it is there, that may be constructed within that.
We'll keep it for hearing on some other days.
Yes, ma'am.
It is pointed out on behalf of the opposite party number 6 that the National Green Tribunal has passed a final order dated 24th September 2021 on the very aspects that have been raised in the present petition. Answer to the petitioner, however, states that they were not parties to the proceedings in the NGT, and they are still agreed by the deviations from the original permissions granted for the project. This on 10th May.
I have a small submission to make. The project is at a very crucial stage of construction. It's getting held up. Each set of petitioners come and stop this.
There is no interim order here.
No. What happens is that financial institutions stop releasing the funds the moment a petition like this is there. So
this petition has been done since 2017, sir.
I bow to that, but after the NGT has passed the orders, this is the only impediment that we are facing from the institutions. Humbly, kindly take it up sometime in March or April at your Lordship's convenience.
Or at 21st April.
Item note 33.
Your Lordship, can turn to page 56, annexure 10 below. The gazette, that is Orissa District Subordinate Courts Non-Judicial Staff Service Methods of Recruitment and Condition of Service Rules 2008.
You challenged this.
At page, your Lordship, kindly see page 57.
No, you have questioned the validity of this.
Pardon?
You have questioned the validity of the act.
No, I am questioning that for declaration of this process server as grade C.
Whatever. All right. List on. Fourth May.
Item 34.
Item in month of March, my lord.
Not possible, sir.
Item 34 and 35, there are a batch of cases where the counter affidavits have been filed, but in some cases counter served and in some cases counter not served. My lord,
all
may kindly
these cases-
grant 2 weeks time to file our reply to the counter affidavits so that the matter can be taken up.
In all these cases, my lord, in all these cases, the virus of an order is under challenge. That has been also repealed.
Oh, sorry?
Virus of an order, 2004 order is under challenge.
Ah.
That has been repealed in 2008.
Will satisfy your lordship that even if it is repealed, it has been acted upon because of the
Repealed.
judgment passed by this
And the
court.
virus of an order which is no more in existence, that order, that virus is challenged in these petitions.
What do you want? That you want to argue the matter today?
That's precisely we are challenging.
Sorry?
Our case, lordship, is the date of the appointment was 90 in between 91 to 93. Now 94 grantinate order came into force. By virtue of the 94 grantinate order, many lectures have been regularized. They have got the
But I
service.
think we already dealt with all this,
And
right?
yes,
Your
yes,
lordship
your lordship
has always
Honorable
dealt with, and that has
Supreme Court,
settled
they
in
lost. Honorable Supreme Court, they lost.
Just
Thereafter, the release.
Anup
Now,
Senapati
in
case that has-
meantime, while pending before the Honorable Supreme Court, they come with, government come with block grant. Instead of
the
granting
judgment
it,
in that
a
Anup
block
Senapati
grant
case.
formula that is 2004 and then the consequential 2009. That is a challenge before your
And
lordship.
2004 order has been repealed in the meantime. by virtue of
2009, we have challenged 2004 as well as 2009 in view of that 2009
And after
order is
getting
the
the benefit
consequential
of
order to the
2008 order,
2004
now they are challenging the validity of
order.
2004.
Well, I think Mr. Khuntia is not correct. What has happened here? In
You
2004,
must see their prayer, whether I am correct or not.
if you want to argue, then we can argue the matters. But there is no time. No difficulty, there is no time, then we have not.
There
so
is no
served the
time
copy
right
of the counter.
at present.
That is the whole problem. You have not served the copy of the
List
counter.
along with whatever those 4 petitions, 3 petitions
19, 20.
on 28 June.
34 and 35.
34 and 35.
Along with my
Let them file counter to the
1819. Rejoinder be filed in the meanwhile.
Well, 18 and 2020.
I don't know.
One matter that's been
May I-
18, sub item 2, I have filed an application for amendment. In that amendment, I have challenged 2009 grantinate order, which lordship was pleased to ask the state government to give a copy for amendment. That they have not served the counter. That amendment may be allowed so that
Let's see, we'll see.
only so that registry will accept it.
All right.
Item number 36.
This is the case with regard to setting up a PET CT scan in the Cancer Institute at Cuttack and other places in Orissa.
Pursuant to Lordship's last direction, my lord. Direction dated 11/11/2021. We have filed a compliance affidavit yesterday. I'm filing the copies, my lord. I'll serve copies.
Now, as far as this affidavit is concerned of yesterday, so now they have taken 2 stands. One stand is they say.
No, I have to file in court. I have to file in court. I have not filed the copies. Court.
The state government's affidavit be brought on record. List on 30th March, sir. 30 March.
Lord, I have instructions in this case that the machinery is going to be shipped in March. So if your lordship calls it in April, maybe the machinery will be installed.
All right. 12th April.
Also, same senior. In July 2021, Mr. Panda had stated before this honorable court
Yes.
that by February these things will be
Yes, my lord.
but
There
now
was
it
a
is-
COVID outbreak in the shop floor at Chicago of Siemens.
All right. 12th
Similar
April.
COVID outbreak there. Now they are shifting it by air.
All right, sir. 12th April. Yes. Carry on.
Item 37.
May I pray, my lord? Item number 36, I am appearing for Maitri Sansad, a letter petitioner in this case, my lord. The opposite party has also filed counter. We have also filed rejoinder.
All right.
Both the matter will be heard together.
Correct.
Item
Obliged.
37. Item number 37.
List on 16th May.
Item number 38.
Lordship, item 38, your lordship. I pray for 4 weeks' time to file my rejoinder affidavit.
All right, rejoinder will file before the next date, 17th May.
Item number 39.
Applies to lordship.
Item 39, Lord.
My lords, item 39, your lordship, before the learned counsel starts to argue, I just want to inform this court that there is a sub item listed in this matter. Your lordship, WPC 23127. Lordship, I just want to inform this court that I want to withdraw this application, your lordship, as per the client's instruction.
All right, 23127, counsel the petitioner seeks leave to withdraw this petition. Dismiss is withdrawn.
But in the first case, Lord, the government has not yet filed counter. Lordship directed to file counter. This is
All right, counter will be filed within 4
Here, my lords, I'm appealing for the opposite parties, my lords. I've taken instruction, my lords. If my lords directs, I'll find an affidavit to that effect regarding construction of that Orissa Adarsh Vidyalaya. I've taken instruction, oral instructions. If my lord directs, I'll find within 10 days, my lords.
Whatever, reply will file within 4 weeks. Joint of the next day. List on 27th April.
Item number 40.
May it please your lordship. Lord, your lordship has had a long day, Lord. Will not bother your lordship today. In fact, Mr. Mishra is also in another court.
Okay.
The opposite party counsel.
All right.
Any other day?
9th May.
Interim order to continue.
Interim order.
I'm obliged.
All right.